We are recording.
All right, thank you. Good afternoon, everyone. Welcome to the Appellate Court. I am Judge Cradle, and I have the privilege of sitting today with Judge Alexander and Judge Levine. This is the matter of LPP Mortgage versus Underwood Towers, AC 43542. This is a virtual argument that is being conducted on the Microsoft Teams platform. It is being live streamed on the Judicial Branch's YouTube channel, and the recording of this argument will be posted on the branch's website. To the extent that there's any protected information involved in this case, it should not be disclosed, and I would remind counsel not to divulge protected information during their argument. To make sure that we can hear and see one another, I will ask everyone to introduce themselves, beginning with the judges, followed by counsel for the appellant, and then counsel for the appellee. I am Judge Cradle.
Judge Alexander.
Judge Doug Levine.
Richard Weinstein for the appellant.
Wesley Horton for the appellee, and I'm here with David Foles and Thomas Witherington.
Okay, thank you. I am able to hear and see everyone, and if during the course of this argument you cannot hear or see everyone, then just bring it to our attention. I will ask everyone to mute their microphones when you are not speaking, just so that we don't have any feedback. You also must keep your camera on at all times during the argument so that we know you are still present, and the judges will do the same. If we have questions, we will raise our hands. If you don't notice us doing that, we'll just jump in and ask the question. Everybody should be mindful that this is a court proceeding, and everyone should conduct themselves as if they were present in the courtroom. Each side will be permitted 20 minutes of argument. The appellant may reserve a portion of that time for rebuttal. The appellant should let me know before he proceeds if he would like rebuttal time, and if so, how much. Judge Alexander has agreed to keep track of the time, and she'll notify you when you have 2 minutes and 1 minute remaining, and also when your time is up. Each of you have received instructions prior to today's argument. Does anyone have any questions before we begin?
No, thank you.
Okay, wonderful. All right, Attorney Weinstein.
Yes, thank you. May it please the court, my name is Richard Weinstein. I represent the appellants in the case at bar. I would respectfully request 5 minutes for rebuttal. Your Honors, this case involves the intersection of the Uniform Commercial Code, and particularly Article 3, and Connecticut foreclosure laws. The issue of standing needs to be addressed first, and if the court decides that issue in favor of the defendants, then the court needs to go no further. In Article 3, Section 309 deals with the instrument, the note. Section 310 deals with the obligation or the debt. The defendants maintain that standing in this case must be determined based on Section 3-310, small b 4. The promissory note, Note B, that the plaintiff based its claims upon was never in its possession. It was lost by HUD. It's the defendant's position that only HUD could enforce the lost instrument in accordance with Section 3-309 B4. And that's 309 has been fully articulated in the recent Seven Oaks case decided by the appellate court. A careful reading of 310 small b shows a progression that is set forth in the code. Under B2, if there is a note, it suspends the debt until the note is dishonored. Under B3, if the note is dishonored, then the obligee can either enforce the debt or the note. But if the note is lost, under B4, the debt may not be enforced, and the rights are limited to enforcement of the note, which sends you back to Section 3-309. And in this case, it could only be enforced by HUD. The plaintiff makes a claim about statute of limitations. It's not a question of right. It's a question of, it is not a question of remedy. It's a question of the underlying right. And I would say it's more akin to 20-329A, the real estate listing requirements, where if there's no listing, then the agent can't sue. Yes, Your Honor.
Is this a suit in law or a suit in equity?
This is a suit both in law and in equity. The first count, of course, the foreclosure count is equity. And the other, I forget if it was 9 other counts, I believe, were in law.
Can you address why Bedford doesn't apply?
Yes, Your Honor. In Bedford, the Supreme Court never addressed Section 310 at all, let alone 310B4, and therefore it doesn't apply. The Supreme Court never reached the issue, and its first impression for this court. This court should keep in mind the policy considerations that are set forth within the code to prevent double recovery. The same concept that's actually included in 49(1) of the Connecticut General Statutes dealing with foreclosures. The policy creates the marketplace for negotiable instruments. In today's marketplace, it's extremely risky for borrowers, as the bank may originate a loan, sell it to a securitized pool, securitized pool hires servicer and special servicers who then purport to make claims in regard to the residential market as well as the commercial market. Beal LPP loaned no money whatsoever to Underwood. It purchased the obligations, approximately $65 million in debt, including the interest, for about $3.6 million. PME, another entity, had purchased the obligation for about $10.5 million just a few years earlier. Once it realized the 2006 call provision had been eliminated, it rescinded the loan with HUD as it realized it could not gain a reasonable return until 2029 when the note becomes due. Article 3 balances the marketplace risks in Section 309 and 310. In 309, a party must post security in order to recover on the loan instrument. And in this case, that would be HUD, in effect, guaranteeing that there wouldn't be a double recovery. No such requirement exists in 310. Yet the plaintiff would have you believe that Beal LPP can somehow proceed without posting any security, and its rights somehow are greater than those of HUD. With all due respect to the plaintiff, it makes no sense under the code. The opposite is true. The Supreme Court did hold in Bedford that the UCC applies in terms of analyzing standing. And then the trial court believed that the Supreme Court had decided that the UCC doesn't apply in foreclosures. We maintain that the Supreme Court did not, in fact, so decide that issue. And as I said earlier, it never addressed 310. So this is first impression for this court. As I said, if the issue of standing is decided in the defendant's favor, then the court needs to go no further. However, otherwise, this court needs to consider the trial court's imposition of the regulatory agreement, the HUD regulatory agreement, notwithstanding the fact that document after document from HUD excluded the regulatory agreement. HUD retains the right to apply, analyze, and interpret its regulations. And it did not and does not give that right to any private party. The court ruled that if there was no requirement to adhere to the regulatory agreement, somehow Underwood could misuse the funds. Respectfully, the court erred. The expense, even without the regulatory agreement, had to be a necessary operating and maintenance expense of the project. So, for example, if the money had been used for a vacation, that clearly would not have been a necessary operating and maintenance expense. There are glaring inconsistencies in the court's analysis in regard to the 6 so-called items of default. The court recognized in footnote 19 of its decision that Beal LPP had abandoned reporting violations, yet the court relied upon alleged violations in its analysis. Another glaring inconsistency is where the court adopted past practices, as it did in analyzing the capital expenditures, but then ignored it when it came to compensation paid to John Scobie and Frontline expenses. The court rejected the largest claim being made by the plaintiff, which was the use of funds for capital improvements and maintenance, which was at least a $3.5 million demand. Ironically, the use of the capital of the funds for capital investment and maintenance provides for the security upon which the plaintiff seeks to foreclose. Underwood had an obligation, as it did at all times, under HUD rules and regulations, and even under mortgage agreements, to maintain decent, safe, and well managed housing. The court claimed that HUD's acceptance of funds, claimed now to be a default by LPP, did not constitute a bar or a waiver, but the court ignored Section E of Note B, which has a waiver provision, but it's prospective in nature. Instead, the court relied on the waiver provision in the mortgage, which is a traditional waiver provision. But the mortgage was written in 1990. The Note B wasn't even written until 1996. And two of the major items claimed as defaults by the plaintiff are both claimed under Note B, that is SCOBY and Frontline expenses. In regard to the analysis of SCOBY, the court cited three bases for default. First, the court relied on violation of the HUD regulations, which of course we maintain it could not do. Then it decided that the payment to SCOBY was a payment to a partner or limited partner, which as a matter of law, he was neither. And lastly, the court decided without any evidence whatsoever that SCOBY's compensation was not a reasonable expense. But even if the court could have reached that decision, it failed to take into consideration the cost to replace SCOBY and hence substitution, which would have reduced the amount of damages. The court, in analyzing the management fees, failed to distinguish between management fees and frontline expenses, which is a term of art used in HUD properties. The reality is that CDC, the manager, could have placed a bookkeeper at the premises and have billed that as a direct expense to Underwood. But instead, it prorated fees, and that is what constitutes the frontline expenses. The court relied upon Note B, which Beal couldn't enforce, in regard to this issue of frontline expenses, because there's a provision in Note B that says the management fee is $8,000. It has no language whatsoever in regard to frontline expenses. And of course, the irony is that what the judge did was really enforce the terms of Note B, which couldn't be enforced. Please keep in mind that Note B was a fully integrated document, and the judge was really relying on parole evidence as to the negotiations that took place that led to Note B. There were exchanges as early as 2001 between HUD and Underwood about frontline expenses. Exhibits 43 and 44 were such an exchange. HUD never declared a default. Again in 2007, exhibits 99 and 100. There were again an exchange between HUD and Underwood. Again, there was no claim of default. In regard to Carbone's use of the apartment, we obviously disputed that it was a distribution. But even if it was a distribution, the Carbone apartment was someplace between $750 and $1,000 a month, depending on which year. It wouldn't have made any difference whatsoever in the net cash payment. I would invite the court to look at Note B, paragraphs 3 and 4. Net cash is paid monthly, but it's determined annually. So obviously, it's the defendants maintain it's paid in arrears. And again, that $750 or $1,000 wouldn't have made any difference because at all times, Underwood always had outstanding bills to pay and outstanding maintenance. In regard to analyzing whether or not the plaintiff sought to artificially accelerate the right to foreclose on the property, I'd ask the court to keep in mind as early as April of 2005, right after it bought the note, because the note was purchased in March of 2005. In Exhibit 63, you will see that the plaintiff was demanding of Underwood certain HUD forms that were no longer in use by HUD. And Underwood immediately responded in Exhibit 64. Notwithstanding that, a year later, in documents Exhibit 79, 85, 87, Beal, LPP were making the same kind of demands, including documents that were not even used by HUD. If the mortgage holder makes a demand upon which it bases acceleration for 1, 2, 3, 4 different defaults, but doesn't prove them all, shouldn't that be a basis to deny the foreclosure and give the owner of the property the opportunity to cure and pay any sums that are legitimately owing? So, for example, if Underwood legitimately owed the $97,000 for the Carbone apartment, in a heartbeat, Underwood would pay it to cure the default. So one of the issues, I'm sorry, Your Honor. Yes, Judge Alexander.
You have just over a minute. I didn't want to interrupt you.
Thank you. In Exhibit 82 in 2006, Beal was demanding 18 items on its list, including $4.1 million for capital expenditures, which, as I said earlier, the court rejected. Yet if we had paid or had agreed to pay all of our funds, we would have had no money to operate the project, which is what led Underwood to bring a declaratory judgment action so we could determine how to operate. Even though we've been at this some 14 years, HUD has never declared a default. And for all these years, we continued to operate the project. Scobie continued to be the manager. We continued to pay Frontline expenses. And then, of course, in 2018, in the fall, the plaintiff was allowed to amend its complaint and claimed another 14 years worth of damages between the time it originally started the complaint and 2020. Contrary to what the judge suggested, the marketplace would not be paralyzed by defendant's interpretation of Section 310. HUD could have enforced it. And obviously, that is a pivotal issue and certainly affects the entire marketplace. Thank you very much. I hope I was close.
Perfect.
Thank you. Attorney Horton.
Yes. Good afternoon, Your Honors. I'm Wesley Horton, and with me are David Folds and Thomas Witherington. I would like to start off by following up on Judge Cradle's question, because the holding in Bedford is that loss of an in personam remedy on the note under 309 does not eliminate, mean you lose an in rem remedy on the mortgage. And the question is, how is that possibly distinguishable from this case? And what Mr. Weinstein said was, well, they didn't look at 310. But that's another way of saying, in other words, the Supreme Court didn't do their job. They stopped at 309. And that's for the Supreme Court to say if they didn't analyze the case properly. And furthermore, there's a reason they stopped at 309, even though he didn't say it. But the reason they stopped at 309 is because if you don't get by 309, you don't get to 310. The appendix by the appellant doesn't include the statutes, but it's in the judge. They're in the judge's decision. DA 220 is 309, and it says a person not in possession of an instrument, that's us, is entitled to enforce the instrument if the person was in possession of the instrument and entitled to enforce it when the loss occurred. Well, we weren't. So you stop right there in Bedford, you stop right here. We can't enforce the note. They couldn't enforce the note. There's no reason to go to 310 because 310 discusses what you can do if you can enforce the note and under what terms. And if you go to 310, which is on DA 223 in the footnote, you see it's B4, as Mr. Weinstein talked about, and there's two sentences in B4. The first one has to do with if the person entitled to enforce the instrument is a person other than the obligee, and it goes on. Well, we're a person other than the obligee, but we're not entitled to enforce it. So the first sentence clearly doesn't apply. And the second sentence says if the obligee, that's HUD, is the person entitled to enforce the instrument but no longer has possession of it because it was lost, stolen, or destroyed, the obligation may not be enforced. Now, what he's trying to say is may not be enforced by anybody, but that sentence only applies to the obligee. That's HUD. And if you're not convinced that I'm right on that, go to the rest of the sentence. It says, and to that extent, the obligee's rights against the obligor are limited. So the first sentence applies to us if we had any rights, but we don't. And the second sentence applies to HUD if they had some rights, but they don't because they transferred it to us. So neither one of those sentences has anything to do because you don't get by 309. And there's another problem with 310. Notice the very end, last clause. It says to this extent, the obligee's rights against the obligor in personam. It has nothing to do with what Bedford was talking about in terms of foreclosing on the mortgage. So now, Mr. Weinstein goes on at page 13 of his brief, and he quotes a case called Citibank versus Stein, which was written by Judge Levine, and it says, there's his quote. In order to have standing to bring a foreclosure action, the plaintiff must, at the time the action is commenced, be entitled to enforce the promissory note that is secured by the property. What's wrong with that quote? He eliminated the first word. The first word in the sentence is generally. Well, sure, generally, because generally you have the note and you can enforce it. It's an unusual situation, as in this situation, where you can't do it. So that quote has nothing to do with what we're talking about here. And in addition, Mr. Weinstein makes a huge fuss about the McKay case from Arkansas, as though that's the one case that's on point. You read that case, and it has nothing to do with the discussion of in personam versus in rem discussion, which our Supreme Court has made very clear just this past few months in the Essigoff case, which I've cited, that there is a huge difference between these two rights. At this point, I want to turn to the merits of his argument. And the first thing I want to do is if your honors could go to page 31 of his brief. And the reason I want your honors to go there, if you could, his blue brief, the original brief, is because I need to clarify something that's implicit in both briefs, but is not stated explicitly. And yet it's perfectly clear when you read what he's written there. Judge Alexander, yes. You'll see the heading there halfway down the page says, at least one ground of default relies entirely upon the regulatory agreement. Now, the obvious implication for this, and I'm sure Attorney Weinstein would agree with me, is that if you don't prove that, then you don't need to look at the regulatory agreement at all. In other words, if all of the four defaults can be determined on a basis other than the regulatory agreement, you don't go to the regulatory agreement. So let's examine what Mr. Weinstein said in this point too. The trial court's determination of Underwood's use of Park Place revenues for its legal fees against Beal Bank and LPP was a default based entirely upon the regulatory agreement and HUD regulations. Now, the memorandum decision discusses that very subject starting at DA 254. DA 254 to 256, and you'll see on the discussion starts on 254, and on 255 he does say the trial judge does say that this is a violation of the handbook, and then at the bottom of the page it goes on, and it refers to Judge Langenbach found that the legal fees are not necessary operating expenses and granted an injunction, and then at the very bottom of the page says several courts, while not addressing the unique type of lawsuit, et cetera, second line, and even without reliance on the HUD handbook. And then it goes on and cites cases. And then 5 lines from the bottom, it says, as a logical matter, it would seem almost self-evident that a borrower should not use rental funds this way. And does that mean that the judge is finding that it was not a necessary operating expense? Because if it was finding that, that's a violation, that's a flat violation and a material violation of the note, which was incorporated into the mortgage document itself. You don't go to the regulatory agreement. So the question is, did the judge find that as a fact? Well, it sounds that way. It's not clear. And what do you do when it's not clear? If you're the appellant, you have to file a motion for articulation. It's obvious when you start at the bottom of page 255 and go through 256 that he's saying something other than it was a violation of the HUD handbook. Otherwise, there's no reason for him to do that. So it's perfectly clear that that's the most likely thing it is. So if you agree that that can be read that way, then that section can be justified without referring in any way to the handbook, the HUD handbook. And if you're there, then you go on to the 3 other issues, and it's clear they don't have anything to do with that. You have the Carbone issue. By the way, Mr. Weinstein does not raise the Carbone issue in any way. This idea that it wouldn't make any different, this is not briefed. The issue of Carbone, and they say, HUD never declared a default. Well, why didn't they declare a default? Because things were concealed from him. The judge said it was bad faith that what they had done concerning the concealing Carbone. What they did was Carbone was a limited partner in the defendant, and Section 26 of the mortgage itself prohibits distributions to a principal, and that was concealed from the auditors, from everybody, certainly from HUD. So when you say they had not moved for default, well, there's a reason they hadn't moved for default. And that also applies to the compensation for Scobie, which was, and that also applies, they didn't know about the management fee situation. So in all those situations, you have a good reason why there wasn't a default by HUD. And Carbone was living there without paying anything, and then eventually he was in the penthouse. The judge said that was in bad faith by the opposition. But one thing that's clear, that has nothing to do with the handbook. That has to do a specific violation of the mortgage. And then the management fees, the Section I of the note, once again, is incorporated into the mortgage, says that the management fees will be $8,000 a month, and and what happened is after this was agreed to, after 3 or 4 years, they added they charged for frontline expenses, which were various types of overhead, in addition to the management fee, and this didn't tell anybody about it. And what Mr. Weinstein now says, well, that's permitted by a HUD document. The judge, and that's just an abusive discretion issue, because the question is, what is a management fee? And the judge says, I'm convinced by the background, the negotiations that led up to this agreement, because you have to remember there was the failure to pay the rents twice. There was a default in this, and then they were negotiating with HUD to get us another bailout. And they said, look, HUD, we're going to reduce our fees. It had previously been 4% of the rents, and it was, and they said, we're going to reduce it. And they had never at that time charged frontline expenses. So, while the frontline expenses were not concealed from HUD, the legal fees were concealed, and Langenbach said they were concealed. The point is that Schumann, yes, Schumann said that they were concealed. So the point is that the judge is simply saying, I'm looking at the at what the negotiations were, and that helps me in determining what the meaning of management fees in, which is just an abuse of discretion issue. And then you have the SCOBY compensation. SCOBY, try to remember, SCOBY was the chief executive officer of the management company. That means, and he was being paid $400,000 a year from the management company. He's basically double dipping, claiming a large sum of money and claiming that as a legitimate business expense. And the judge said that's not a proper business expense. Now, Mr. Weinstein mentions that he was not a limited partner, and therefore he says one of the judge's reasoning is not good. But that's just one of the three reasons given. The main reason is that it was not a legitimate expense for the chief executive officer of the management company, who wasn't charging for his compensation on any one of the other plans in New York or elsewhere where they had other operations, but just charging it for ours was an improper double charge. And so there you have it. And the SCOBY compensation, by not being a reasonable and necessary expense, was a violation not only of the handbook, but also of the note, which was incorporated into the mortgage. So all four of the defaults are based on a reason having nothing to do with the regulatory agreement. So, but assume for the sake of argument that you need to go to the regulatory agreement. And that is at DA 397. And you'll first of all see that it specifically says that the note and all of its terms are incorporated hereby. And then there's and Mr. Weinstein spends most of his time talking about issue 3, which is that the regulatory agreement is incorporated into the mortgage, and he gives 11 reasons why it's not incorporated in the mortgage. Let's assume for the sake of argument that he's right on one or more of those. You don't need Section 3 in order to affirm this agreement, because go to Section 4. Section 4 says that all rents, profits, and income from the property covered by this mortgage are hereby assigned to the grantor for the purpose of discharging the debt hereby secured. It doesn't say a word there about the regulatory agreement, and it also says it doesn't say they're conditionally assigned. It just says they're assigned. And what does the second sentence say? Permission is hereby given to grantor so long as no default exists hereunder to collect such rents, profits, and income for use in accordance with the terms of the regulatory agreement. It doesn't make any difference whether the regulatory agreement is in effect or isn't in effect or has been terminated. You have to go to that document to see what it means. That's all. It could say in accordance with the terms of the United States Articles of Confederation. I mean, you're just going there to see what the term means. It doesn't make any difference whether it's incorporated or not. So you can decide this case entirely on the basis of Section 4.
Go through paragraph 1. Paragraph 1 also.
I'm sorry. Excuse me just a second.
Paragraph 1 also.
Oh, yes. Yes. And I would also refer to, it says, paragraph 1, that the grantor will pay the note at all times and in the manners provided herein. And then that was amended in 1995 to involve both notes A and note B. Excuse me. I want to say a word about damages, and that is that the issue of damages was raised in his brief concerning a breach of contract. It was not raised in his brief concerning conversion, and the judge ruled for damages both on conversion and on breach of contract. And the conversion issue is only found in a footnote in his original brief, so that it's improper for that. And in his reply brief, which I don't think you have several cases say you can't do that. But he put something in his case, and he attacks a case we cited called CXA 16 case, which was a case most on point because it's a case. There's no appellate case in Connecticut on the subject, and there's a rents case that's directly on point from Michigan. And he says, well, that's because of a statute. And I have the case in front of me, and it says it rules both on the statute and on the common law. So I urge you to take a look at the CXA 16 case. It's directly on point. And the other thing I want to mention to you is the final claim against CDC. And that was an unjust enrichment claim. You'll notice he says nothing about it not being unjust enrichment. There's no question, the judge made a finding on the fact clearly that there was a benefit to CDC. Mr. Weinstein's entire argument on the CDC issue is that, that's an issue between the defendant and CDC. Unjust enrichment has to do with us and the defendant. And that is contrary to Connecticut law. The Connecticut case on point is New Hartford versus the Connecticut Resources Recovery Authority, which I've cited. But I want to read just one part, and that says on page 468, although unjust enrichment typically arises from a plaintiff's direct transfer of benefits to a defendant, it also may be indirect, involving, for example, a transfer of a benefit from a third party, in this case it would be the defendant, to a defendant, in this case would be CDC, when the plaintiff has a superior equitable entitlement to that benefit. What had happened in the New Hartford case is the defendant charged the plaintiff for something, and then the defendant sued its own lawyers for malpractice and won. But, they had already, already gotten the recovery from the plaintiff before they sued the lawyers. So it was obvious that it was the plaintiffs that were entitled to the money, not the defendant in the case. So they ordered the defendant to pay over the malpractice proceeds they had gotten to the plaintiff because the plaintiff had already paid the defendant for what was owed before there was any malpractice in the case. So that case is directly on point. And I'm sorry, Judge Alexander, were you?
You were down to about a minute. You have 10 seconds. But
10 seconds. Then could I have just 1 second? Is there something?
Of course.
I think I'm safe. Good. Then I'm all set, and thank you very much.
All right, thank you.
Counsel completely misunderstands or misstates Section 3-310, particularly B. The obligee is the party that's claiming the money is due and owing, whether it's under a note or whether it's under the debt. And what the code is providing for is whoever has the claim has to deal with these sections. And therefore, even though counsel dismisses it, consistent with what the McKay case analyzed, which is the only case in the country that deals with 310, necessarily it's only HUD that could enforce the obligation. It is preposterous, with all due respect to my old friend, Attorney Horton, to claim that somehow the rights of BLLPP are superior to the rights of HUD. HUD would have to put up security under 309, but BLLPP wouldn't. That makes no sense. The assignee's rights can never be greater than the assignor's, and yet that's what counsel is suggesting. In terms of the assignment of rents, again, counsel has a very convenient way of reading the paragraph. If you read the entirety of the paragraph, it's clearly a conditional assignment of rents. There's no provision in it that in any way precludes Underwood from using the monies unless and until a default is declared. Counsel cites Michigan law dealing, I believe, with this issue of conversion or dealing with the use of the rents. What you would find is that Connecticut's law is atypical in terms of mortgages and foreclosures. In 1990, I remember, 91, whatever it was, that they decided they wanted to put in non-judicial foreclosures in Connecticut. It never happened. Connecticut is probably the only state or one of two states that has both judicial foreclosure, where you have strict, and a foreclosure by sale. I would also point out, when counsel claims that the legal fees were concealed, they were discussed in Exhibits 99 and 100, which was an exchange with HUD. And again, there was no declaration of default. Counsel claimed the Frontline expenses were concealed. In every single financial statement, I believe it started in 1999 or 2000, I think it was 99, Frontline expenses are identified. Those statements went to HUD. There was never a claim of default by HUD. And if you're going to use the regulatory agreement for purposes of defining what you can and cannot spend, well, then the regulatory agreement provides for Frontline expenses. So you can't have it both ways. And that's exactly what counsel's arguing. Just a few more points.
You have 2 minutes.
2 minutes? Okay. I would just point out to the court that what the plaintiff is doing in this foreclosure through the multiple counts 9 through 10, I'm sorry, counts 2 through 10, is claiming multiple damages, repetitive in nature, because if the money had been paid to the holder of the debt, the holder of the note, that it would have reduced the amount of the claim and debt under the first count. And once the plaintiff would take title to the property, the debt is satisfied except through a deficiency. There can be no claim for deficiency. So in effect, the plaintiff is getting double, triple, quadruple damages. I'd point out to the court that in the 35 years Underwood has operated, and it's still subject to a first mortgage in favor of HUD, there's never been a default. I would point out to the court that there's not a single case in the country that interprets 310 in the manner that Attorney Horton is suggesting. And lastly, I'd point out to the court that there isn't a single case in the United States in which a state court has interpreted and applied HUD rules and regulations, except this one. There's one federal court bankruptcy case that the plaintiff cites, this Tobacco Row case, but we don't even know if the issue was raised. So here we have gone really into the abyss. HUD reserved all of its rights under the HUD regulatory agreement, and it never should have come into this case. Most of the trial time was spent on HUD rules and regulations. Thank you very much, Your Honors.
Thank you.
For your time.
All right, thank you. We have the next argument that is related, but I believe that is also on a separate link, which commences at 3:45, so in 3 minutes. So Attorney Horton, I believe you're arguing that one as well. So you'll have to go over to that link. Thank you. So we'll stand in recess till 3:45.